On today's, on the other hand, we talk with someone working to help Arkansans come together and make our state better. Here's a sneak preview.
The press in this capacity are representatives of the people seeking information. The press, just like the citizens, just like the government, and just like the laws, are imperfect. So they don't always get it right, but they act as a conduit for the people for transparency. So I've always been a strong advocate for freedom of the press.
This is On the Other Hand, a podcast sponsored by Braver Angels Arkansas, where hope and common ground meet.
Each episode features community leaders from Arkansas and beyond, sharing stories and insights on how we can strengthen our relationships and our communities together. In this first part of our conversation with Robert Steinbuch, Rob described multiple things that he uses to guide his philosophy in terms of law and transparency and accountability. Now let's get to the second part of our conversation with Rob Steinbuch. A lot of people would probably label you as a political conservative, but as all of us know, people are so much more complex than labels. So how would you describe your political philosophy?
Well, I think you're right. I think I am conservative, and it varies on some issues. And I don't take my marching orders from some pamphlet, say, that says these are the conservative views, make my own mind up on any given issue. But if you look across the spectrum of issues, my views tend to line up with what we nowadays call conservative. Sometimes it's called classical liberal, but in America, as you know, liberal has become more a descriptor of the left, and whatever, it doesn't matter what, just as long as we understand the language that we're using. In modern parlance, conservative is the best descriptor for my views generally.
Yeah, that makes sense. And of course, these things change depending on who's in office as well. So you mentioned that sometimes you change your mind. And it sounds like that probably happens more often than most of us talk about in the public. But I'm curious what kind of issues might have led to your thinking evolving over time because of engaging with someone perhaps that you originally disagreed with.
Well, the one that comes most easily in mind is a rather old one, I must concede, but it was way back when there was the issue of flag burning before the Supreme Court gave an opinion that said flag burning is protected speech. And of course, I found flag burning to be, I don't like it. I don't like when people burn the American flag. And at first, and people said, well, that's not protected speech. Of course, you're not saying anything, you're burning a flag. And I, for a very short time, mind you, but nonetheless thought, well, that's right, that, that's an act. But then I realized, but the act is clearly communicative. It's clearly designed to say something, because you're not burning a sofa. You're burning an American flag to show your disapproval, and you're entitled to disapprove. And so it didn't take very long, but then I came to the conclusion that, notwithstanding that I don't like it, that's kind of the point. In fact, that's a type of speech and clearly protected. After all, the First Amendment isn't designed to protect greeting cards and nursery rhymes. It's designed to protect commentary that at least some people don't like. Because if nobody objected, there'd never be a problem to that speech. The First Amendment is only designed to protect speech that other people don't like, because that's where the controversy will arise. And so I quickly came to the conclusion, albeit a different one than I started with, that flag burning is protected speech and must be permitted under the Constitution.
Well, Rob, tell me what you think your strongest argument is that you hear from your ideological opponents. One that you hear and you say, well, maybe it deserves more serious consideration than maybe it receives.
Well, I think my ideological opponents make some good points. We have a state now that is overwhelmingly Republican in terms of the state legislature and the constitutional officers. All of the constitutional officers are Republican. 29-ish out of 35, meaning I don't remember the precise number of state senators are Republican, and 80 out of 100 state representatives are Republican. And so when you have such a dominance of either party, you have a tendency to be less concerned about transparency, because transparency is usually by the folks out of power looking at what the folks in power have to say. And there's a very small minority of folks out of power in terms of the actual seats. The population is probably not quite as split drastically. I think that an apt concern from the Democrats in Arkansas is that we need to protect the Arkansas Freedom of Information Act. Now, I work with a number of Republicans who have the same belief. And in fact, I will remind you that several years ago, there was an effort to significantly cut back on the Freedom of Information Act. There was a bill by David Ray out of North Little Rock, who really, the contents of the bill would have limited the Freedom of Information Act significantly. And I opposed it. I testified against it. And it was Republicans who killed that bill. Democrats can't kill a bill. Democrats can't pass a bill, either one on their own. They can only contribute. And so Republicans killed that bill, and that was a good thing. To be clear, I think overall Republicans agree with me on transparency, but there is a vein of Republicans who don't, as exemplified by that bill. And that's a problem. And that's a function, I believe, of the supermajorities that we have in Arkansas.
I really appreciate hearing that. That suggests that the Freedom of Information Act is a somewhat of a bipartisan concern where a lot of people on both sides share it. And it also, I think, is a good indication that for you, you go by principles and values rather than a tribal affiliation being your primary concern. That's one of the things we talk about in Braver Angels is going by values over tribe. Sometimes you have to stand up to your tribe if you think they're going against really important long-held values. So I appreciate hearing that. Since you mentioned this, let's move then a little more in detail into the Freedom of Information Act and the whole idea of transparency and government accountability. How did you first get started in that work? Was that from David Ray's legislation, or does it come before that?
No, well before that. In fact, I was doing research here in Arkansas on admissions to law school, and I was seeking data from my university on admissions, and I was dealing with affirmative action and trying to see the effects of affirmative action. And my university, my law school, became resistant to turning over information to me under a previous dean, two deans ago, I think, something like that. And I knew that he was wrong on the law. And a former colleague of mine was the expert on the Arkansas Freedom of Information Act, and he and a fellow from Fayetteville's law school were the authors of that treatise I had mentioned that I'm now the author of. And so I started to dig into the treatise. I started to consult regularly with this former colleague of mine, and I used the Freedom of Information Act to gather the information that I was looking for. It was through that I also got to know the two authors. Well, I knew one very well already, my colleague, and I got to know the other author. And then when their book was coming due for a new edition, neither one of them any longer lived in Arkansas. And I said, well, let's put out a new edition. And if you're interested, I'd be happy to join you. And they said, that's great. In fact, we'd like to do something better than that or more than that. And that is, you join us for this edition, and then you take over the book entirely. And I had hoped that they'd want to keep their names on the book, but they said, no. In a complimentary way, they said, this is all yours, and we don't want to muddy the waters with people thinking that we're writing the new editions. The one edition, all three of us wrote, and then the next edition and thereafter has always been mine. And the research that I did ultimately led to several papers, one of which, maybe they were all co-authored, come to think of it, I can't remember now, but one of which I co-authored with an academic out of UCLA, and that was cited by Justice Thomas in the Supreme Court opinion, striking down affirmative action in higher education and elsewhere, I believe, but explicitly in higher education. And so it was really a productive effort, but I sort of backdoored my way into the Freedom of Information Act by using it, by that public service that we had discussed earlier in your show.
If I understand you right, then correct me if I'm wrong, but it sounds like then your first major work on the Freedom of Information Act came about when you started exploring with your own employer some things that they didn't. So you basically were kind of rattling the cage of your own employer, right?
That's absolutely right. And that created some controversy, needless to say. But, the thing about transparency is it's not only good for the other guy. You've got to live by that principle. And too often, by the way, I've seen this in academia where academics preach all sorts of virtues for everybody else, but not themselves. I went to a conference recently for the American Association of Law Schools, and they were talking about free speech on campus and how academic speech was being shut down, they said. And I asked the question, I said, well, I think there are several examples of academic freedom being shut down. And the examples that you have been giving are all examples of folks on the right shutting down speech by folks on the left. But there have been perhaps even more examples of the opposite. And the one example that I raised was this federal judge went to go speak at Stanford, and the students, as well as an administrator, effectively shut him down. And I mentioned that, and there was this professor, I think from BU, who said, well, that didn't happen. And I said, I watched the video. And by the way, I've since gone back and watched the video, and it just happened. So part of the problem, we're talking about the left and right and how do we come together, is you can have your own opinions, but you can't have your own facts. Facts are facts. And I thought that was really a problem. And that was a problem by somebody on the left. But I recently went on a radio program here in Little Rock. I go on regularly on local radio and conservative radio. And the producer of the show, meaning not the host, but the producer, on a day that I wasn't there, I heard her on the radio making these sort of patently false claims about the history of Israel, the history of how a Jewish state came about. And I called her out on the radio, and she was displeased by that. And she probably won't like the fact that I'm going to do the same in this Friday's column in the Democrat Gazette, because it doesn't matter if you're on the left, doesn't matter if you're on the right. You're not entitled to your own facts. You are entitled to your own opinions.
So you're definitely not afraid of a fight. Gotcha. And in the interest of your greater values, which is an important distinction.
When I got the job at the Democrat Gazette, I interviewed with the then publisher, Walter Hussman, who essentially started the paper in the form that it is now and ran it for some 30 years, I think, give or take, meaning I don't know precisely. And he said that, he goes, I want you to respond. Some people say that you like to fight, like to get into a fight. And I said, maybe yes and no, meaning I don't like to fight. I find it draining to be in a fight. I said, but I dislike something else more, and that is bullies and people taking advantage of others. And so if given the choice between engaging in a fight, not a physical fight, but an argument, and allowing bullies to prevail, like existed in both contexts that I just described, I'm going to take on those bullies and challenge them when they spew falsehoods to mislead the people.
Wow. There are so many different places we could go here. So, Rob, you've mentioned the treatise that you've written. I don't even know where to get that. I'm guessing a person that was interested could probably get that on Amazon, or I don't even know if it's called treatise but what I'm wanting to know, first, I would like to know where they can get it, but I also would like to know if there was some just boiling it down, what ordinary citizens should understand about the Freedom of Information Act.
Yes, let me address both. The treatise is called the Arkansas Freedom of Information Act. The new edition is coming out shortly, and indeed, I would recommend people wait for the new edition. It's going to be the 10th edition, and you'll know it's the new edition because it's light blue. The current version is burgundy. So at this juncture, I would actually recommend people don't buy the burgundy version anymore because it will be outdated in a matter of months, wait for the light blue version to come out. It's rather expensive because it's published by a national publisher, by Lexis. You may have heard of them. And you can go on the LexisNexis website and look in the book section for the Arkansas Freedom of Information Act book. And I can't recall how much it is, but it's not cheap, unfortunately. But I get it. I mean, I'm not complaining about the price. My point simply is when you publish with a national publisher that has a lot of infrastructure, there's going to be a cost with that. But the flip side is you get a publication that is respected and recognized nationwide. I like to give a little primer on the Arkansas Freedom of Information Act, and that is that folks are entitled to public records unless there is an exception for the public records. And there are quite a number of exceptions, and I most certainly won't be able to cover all of them. But first, how do you make a Freedom of Information Act request? Virtually any way you want, but the smart way is to do it in writing. And I recommend people send an email. And you can send an email. You find out the agency, the entity that you're communicating with, and you do a Google search to see if they have a Freedom of Information Act person, an officer. Not all do, but if they do, that's clearly the person to contact. And if that's not the person, generally you try to find the information for that top dog, as I like to say, and you send it to that person, and that person will redirect it to the right person. They are not permitted to charge you for the labor for any request, because otherwise, needless to say, it would be very expensive in short order. And not only that's one reason that we don't charge for labor, the other reason is it's already paid for. Meaning every government employee who's hired, part of their job is to respond, be it directly or indirectly, to Freedom of Information Act requests. Indirectly, if they're not the person in charge of it, well, if they have the records, they have to send it to the person in charge, and then the person does the rest and sends it out. So why would a citizen have to pay for that labor when the citizen has paid taxes already for that labor? And just now, recently, a journalist contacted me and showed me a bill that some locality sought to charge that journalist for retrieving records. And in the bill, it said, well, it's going to take 10 hours to retrieve those records. The labor cost for that is such and such. It's going to take 10 hours to redact certain information due to exemptions in the FOIA. That'll cost such and such. And so your total is $30,000. And I wrote him back and I said, feel free to quote me on this. That bill is illegal and that a government official should be criminally prosecuted because the Arkansas Freedom of Information Act has a criminal provision in it for its violation. And that would be a perfect example of a criminal violation. It was patently absurd. It's always a challenge to get people to comply. So I recommend you send an email, you be detailed in what you're requesting, you be narrow in what you're requesting, because you can always request more. But if you request a lot up front, remember, you'll get a lot up front. And why do you want to go through all that material? Make a narrow request, restricted by person, restricted by date, and tell the folks to send it back to you digitally in your email. And this way, there's no copying charges, because they are allowed to charge you for the physical copies, but there aren't any physical copies if they digitally reproduce it. And so that's kind of my broad overview. And then there are all sorts of exceptions, medical exceptions, evaluative record exceptions. And then, you'll have to look at the treatise or other resources to drill down on those. But there's a lot you can get.
One other question before we move to another topic. Legitimate limits of government transparency. We have times at which government officials, not just because of the cost, but they think they don't have to give the information out. When is it appropriate?
The Freedom of Information Act in Arkansas is laden with exemptions. I want to say there's some 25 exemptions, and that's just explicit exemptions within the Freedom of Information Act. And then there are other laws that build into the separate laws exemptions to the Freedom of Information Act that are not directly incorporated into the Freedom of Information Act. So there are plenty of areas in which a government can not disclose information. And many, indeed, likely most of them, I think, are entirely sound exemptions. Like I say, though, there's just too many to go through to list here, but there are plenty of exemptions. Now, the difference between the Arkansas Freedom of Information Act and say the federal Freedom of Information Act is the federal Freedom of Information Act has what's called the deliberative process privilege, which is so broad that it essentially swallows the act. And it says, well, any discussions about proposed policy are off limits in terms of transparency. That's the kind of stuff you want to know about before policy's passed, right? The people should know that there is contemplation of a change in policy before it actually becomes policy. Otherwise, what's the point? So you can go too far. And part of that effort several years ago that I described from David Ray sought to go too far. But there are just, I want to say countless, but it's not countless. We could count them. There are many exceptions already built in to the act itself, and then other laws that limit what the public can get from the government.
So you believe Arkansas's Freedom of Information Act is a good one at this point, the way it's
It's an
currently
excellent one, but it's not perfect because there's no such thing as a perfect act. I've never seen a law that's perfect because we write them, right? I mean, it's a bunch of words put down on paper designed to control the behavior of people one way or another, to prevent them from doing something or affirmatively requiring them to do something. And no law captures every circumstance in advance. So none of them are perfect. So when I hear people say, oh, well, it's an imperfect law. Yeah, of course it is, because any law, every law is imperfect. The question is whether any given proposed change makes it better or worse. So starting with the notion that it's imperfect doesn't get you anywhere. The question is, what is your proposal and in which direction does it move the law? That's the relevant inquiry.
Okay, now I want to move us to a little different topic. Let's talk about the First Amendment to the U.S. Constitution and one of its rights, that is the right to a free press. I think most of us agree that's very important. And you write this, and you've mentioned this opinion column you write for the Arkansas Democrat-Gazette. So given both that, a member of the press, of the free press, and being an attorney, tell us about the importance you think about in terms of a strong free press in sustaining government transparency and accountability.
The free press and transparency, which is one of my academic interests, go hand in hand. And here's the reason. Because the press acts as a quasi-representative of the people. Yes, many people, particularly in Arkansas, make Freedom of Information Act requests, but the most impactful Freedom of Information Act requests across the country, historically, I would venture, I haven't done an empirical study, come from the press, because that's their job, is to look into issues. And so when people say, well, the press, why is the press using it? This is designed for the people. Yes, but the press in this capacity are representatives of the people seeking information. The press, just like the citizens, just like the government, and just like the laws, are imperfect. So they don't always get it right, but they act as a conduit for the people for transparency. So I've always been a strong advocate for freedom of the press. That doesn't mean there aren't limits on the First Amendment, including on the press, because I just litigated a defamation case. Now, it wasn't against the media, but one could envision a defamation case brought against the media, and they have happened. There was a famous case with Richard Jewell and the Atlanta Olympic bombing, and he was a security guard who was trying to be helpful, and the media basically chewed him up and made him into someone who was involved in the bombing. And now it's pretty definitive that it was entirely untrue. So that's an example where the press had overstepped their bounds. And I think it was NBC that wound up paying either a big judgment or a big settlement. I think it was a settlement, but I'm not sure.
Okay. Well, in terms of the free press, today's environment, the computers, the digital environment we're in, social media, internet, and all, I think we all understand that there's some really serious challenges that come with that. Part of that challenge is that it makes it much easier for the spread of inaccurate information. And there's a great deal of effort that appears to be successful in using online communication to manipulate citizens. So I wonder, given that challenge, what thoughts do you have about how we can protect these strong free speech principles, but also maintain a civil discourse when we're facing all this online outrage and misinformation?
I think I mentioned it earlier with you that I was on local radio and this producer was making these comments and I said, well, you can't say that. And she goes, well, I spoke to the ex-wife of this candidate. I said, you don't understand. When you're a journalist, you have an ethical obligation to confirm the information that you're presenting. And she goes, well, how do you know it's not true? And I said, precisely. Meaning, it's not my burden to know that it's not true. It's your burden to meet some threshold that it's true. And she said, well, I spoke to the wife. And I said, here's the deal. If a couple has gotten divorced or is getting divorced, the statement from either side is not enough to know something is true. I don't care what the statement is. If there's a disagreement between members of a couple that are getting divorced, neither person's statement is sufficient to establish the truth of that statement. You need to do more. As I said to this producer, you need to do better. And so that's one thing, is we need to maintain journalistic ethics for journalists. But as you aptly point out, we also have another problem. Social media is unregulated effectively. I mean, the people on social media literally are not journalists. Now, there were these attempts, largely during the Biden administration, to sort of lean on the companies, the social media companies, to restrict what people were saying, and by government. And I'm always concerned by that, because it strikes me that when you have those efforts, they wind up screening off one set of information or misinformation, but not another set of information or misinformation. So I'm extremely cautious about anything like that. I much prefer to allow the market, as well as things like defamation law, to regulate that behavior, rather than the executive branch of any level of government to step in directly. That concerns me more.
So it's basically, if I understand you, then don't pass new laws requiring social media to restrict the speech of the people who use it, but just let people sue it if they go too far.
Generally, and in fact, there is a problem that there's an old rule when the internet came about that gave immunity to the carriers, internet carriers, for things said on their, do we call it airwaves? I don't know what we call them, but whatever it is. And that law needs to be updated because that's outdated. So we need to ensure that people who are involved in misinformation that could give rise to an existing cause of action actually are subject to that cause of action. And so I think that old rule needs to be revisited.
Thanks for joining us for this second part of today's conversation with Rob Steinbuch. We hope our conversation with Rob helped you get to know him a bit better, and that it gave you a little more hope that together we can do good things.
If you liked what you heard today, share the episode with a friend and help us spread stories of bridge building across Arkansas. And remember, On the Other Hand offers dozens of other interviews just like this one. You can find On the Other Hand in your favorite podcast app or on the podcast page of the Braver Angels Arkansas website at arkansas.braverangels.org.
On the Other Hand is sponsored by Braver Angels Arkansas, who is a community of citizens working together to bridge our divides and to build a stronger, more connected Arkansas. Music was composed by Randall Standridge of Jonesboro, Arkansas, and was performed by the University of Northern Colorado Symphonic Band. Dr. Richard Main conducted.
From your hosts, Lynn White
and April Chatham Carpenter.
Join us in working to make our relationships and communities better.